If you have a child in a public school anywhere in the Sixth Circuit, what I am about to explain means your child's constitutional rights inside that school building are significantly more limited than you probably realize. And the decision that proved it was issued recently by the Sixth Circuit Court of Appeals in Halasz versus Cass City Public Schools. This ruling did not make national headlines the way it deserved to. By the end of this video, you will know all the implications. So let's get into it. It quietly established jurisprudence defining the outer limit of what school officials and police can do to your child, their backpack, their locker, their body, and their words. Without a warrant, without Miranda rights, and without telling them they are the target of a criminal investigation. And the answer, under this decision, is substantially more than most parents know. Subscribe now because the intersection of Fourth Amendment search protections, Miranda rights, and school safety policies directly affects every family with children in public schools, and Halasz gives school administrators and law enforcement powers in school settings that they do not possess on the street outside those same buildings. On November 30th, 2021, a student at Oxford High School in Michigan walked in and opened fire, killing 4 students and injuring 7 others, the deadliest school shooting in Michigan history. The aftermath produced changes in policy, heightened threat assessment protocols, and an institutional determination by schools across Michigan to act swiftly on any credible threat allegation. Against this backdrop, an 8th grade student at Cass City Public Schools, identified only as HH, allegedly told classmates he intended to bring a gun to school. School administrators pulled HH from class, questioned him, had police question him without reading Miranda warnings, and searched his person, backpack, and locker. No weapon was found. No prior disciplinary history for weapons existed. HH's family filed suit arguing violations of Fourth and Fifth Amendment rights. The Sixth Circuit ruled against HH on December 18, 2025. Let me break down what the Sixth Circuit held, the specific constitutional questions it resolved, what legal standards now apply to your child at school, what the Miranda failure means, and what every parent and student needs to know. Number 1. The Fourth Amendment standard the court applied. The TLO Foundation. The Fourth Amendment's protection against unreasonable search and seizure has never applied to public schools with the same force it applies to citizens on the street or in their homes. The governing Supreme Court precedent is New Jersey versus TLO, 1985, which established that searches of students by school officials require only reasonable suspicion, rather than the probable cause required for law enforcement searches of ordinary citizens. Reasonable suspicion requires only articulable facts, suggesting the student has violated school rules or the law, a significantly lower bar than probable cause. But TLO applied to routine school discipline situations. What Halasz addresses is a different scenario, a credible threat of an active shooter in the post-Oxford institutional climate. The public safety doctrine in Halasz, the Sixth Circuit did not simply apply TLO, it applied TLO filtered through what the court called the public safety doctrine in school settings. The court held that when school officials face a specific, credible allegation that a student intends to bring a weapon to school, particularly in the aftermath of a nearby mass shooting, the balance between student privacy and institutional safety tilts further toward safety than ordinary TLO would require. The court wrote that the reasonable suspicion standard must be applied with even greater deference to administrator judgment when the potential consequence of being wrong is mass casualty violence. In practical terms, Halasz held that classmate reports of a stated intention to bring a gun to school, without independent verification and without evidence of actual weapon possession, was sufficient to justify the search that occurred. What this means for the search standard. In the Sixth Circuit, a school official now has legal authority to search a student's person, backpack, and locker based on a classmate report that the student said something threatening, no corroborating evidence, no independent verification, and the general institutional context of elevated threat awareness following a significant regional school shooting. The court did not require the school to verify the credibility of the report before searching. Number 2, the Miranda question and what the court decided. The Miranda failure. HH was taken from class and questioned by school administrators and police. At no point was he informed of the right to remain silent, that anything he said could be used against him, or that he had the right to counsel. The Miranda warnings law enforcement must provide before custodial interrogation. HH and his family argued the interrogation was custodial. He was taken from class, not free to leave, and police were directly questioning him about conduct that could result in criminal charges. Why the court ruled Miranda was not required. The Sixth Circuit's analysis turned on the distinction between school disciplinary investigation and custodial criminal interrogation. Miranda v. Arizona applies to custodial interrogation by law enforcement. The court held that the school environment fundamentally alters the custodial analysis. A student pulled from class by a school administrator is not, in the legal sense, in custody in the way Miranda contemplates, even when police are present. The school context transforms the legal character of the encounter in ways that can remove the Miranda requirement. The practical consequence: H.H. was questioned by police in the presence of school officials without Miranda warnings in circumstances where he was not free to leave. Everything he said was legally usable. The court said that was constitutional. The implication is direct. Your child can be questioned by school officials and participating police officers about conduct that could result in criminal charges without being advised of the right to remain silent, and those statements are fair game for use against them. Number 3. What schools can now do in the Sixth Circuit and the national spread. Searches without prior verification. Following Halasz, a school in Michigan, Ohio, Kentucky, or Tennessee can search a student's person, backpack, and locker based on another student's report of threatening statements, without independently verifying the report's credibility and without evidence of actual weapon possession. The reported statement meets the reasonable suspicion threshold in weapon threat contexts. Combined administrative and police interrogation. Schools can involve police in student interrogations about potential criminal conduct without triggering Miranda warnings, as long as the interrogation occurs in the school setting and is framed as part of a school disciplinary investigation, even where criminal investigation simultaneously occurs. The spread beyond the Sixth Circuit. Halasz is binding in Michigan, Ohio, Kentucky, and Tennessee. Courts in other circuits are not bound by it, but may follow it as persuasive authority. The TLO framework is federal, and the public safety doctrine rationale is not circuit-specific. The institutional post-Oxford pressure on schools to act decisively on weapon threats exists in every state. Administrators in California, Texas, Florida, and New York operate under the same institutional pressure that produced the Halasz search. The legal framework that authorized that search is spreading. Number 4. The limits the court did not eliminate. Reasonable suspicion still required. Halasz did not eliminate the reasonable suspicion requirement. It applied it with significant deference to administrator judgment in weapon threat contexts. A search based on no articulable facts, a hunch, a student's appearance, race, gender, or associations alone, would not satisfy even Halasz. The reported threatening statement remains the anchor of the court's reasoning. Individualized suspicion still required. TLO and its progeny require individualized suspicion directed at the specific student being searched. A school cannot search an entire classroom because one student reported an unidentified person made threats. The suspicion must point to the specific individual searched. Scope must be proportionate. The scope of the search must be reasonably related to the objective. Halasz involved a weapon threat, so searching spaces where a weapon could be hidden, person, backpack, locker, was proportionate. Searching a student's phone, private messages, or social media accounts under the weapon threat framework requires additional authorization beyond what Halasz provides. Fifth Amendment at subsequent proceedings. Even where Miranda warnings were not required during school interrogation, statements obtained in school settings cannot automatically be imported to formal criminal proceedings if the questioning later shifts to custodial interrogation by police outside the school setting. The Miranda analysis remains context-dependent. Number 5. What parents and students must know and do. Talk to your children before an incident. Your child should understand they have limited Fourth Amendment rights in school. If called to an administrator's office with police present, they are in a legally distinct environment from the street outside. They can ask whether they are in trouble, ask to contact a parent, and ask whether they should have an attorney present. They do not have an automatic right to remain silent in the school disciplinary context, but they can and should request parental contact before answering questions about potentially criminal conduct. Request parental presence before questioning. Many states have laws or school policies requiring notification before extended interrogations, particularly when police are present. Know your state's rules. If your child is questioned without notification in circumstances involving potential criminal conduct, that procedural violation may affect the admissibility of any statements made. Document everything after an incident. If your child is searched or questioned under weapon threat allegations, get the written incident report from school. Document what was said by whom. Note whether police were present. Note whether Miranda warnings were given, and consult a civil rights attorney before your child makes further statements to anyone. Understand the post-Halasz landscape. Halasz is not a license for unlimited school searches. It expands administrator authority in specific weapon threat contexts within defined limits. Individualized suspicion, proportionate scope, articulable facts grounding the search. If your child is searched without meeting even this standard, the search remains challengeable. If you are in the Sixth Circuit, Michigan, Ohio, Kentucky, Tennessee, Halasz is binding in your circuit. Contact the ACLU chapter in your state for updated guidance on student rights under this standard. Bottom line, Halasz versus Cass City Public Schools, Sixth Circuit, December 18, 2025. Classmate reports of weapon threat statements alone constitute reasonable suspicion for searching students' person, backpack, and locker under TLO applied through the Public Safety Doctrine. Combined school police interrogations do not automatically trigger Miranda. What changed? Reasonable suspicion threshold requires less corroboration in weapon threat contexts. Public Safety Doctrine tilts balance toward institutional security. Police participation does not automatically trigger Miranda. What did not change? Individualized suspicion still required. Proportionate scope required. Random class-wide searches prohibited. School interrogation statements cannot automatically transfer to criminal proceedings. What parents and students must do: understand the limited Fourth Amendment environment in schools. Request parental presence before answering questions about potentially criminal conduct. Document all search and interrogation incidents. Consult a civil rights attorney if limits described were not followed. Subscribe because school safety law is developing rapidly post-Oxford and post-Uvalde, and every court addressing these questions builds the framework defining your child's constitutional rights inside school buildings.